By the time a CPS case reaches a 366.26 hearing, most parents think the outcome has already been decided. They walk into court believing the judge is there to rubber stamp termination of parental rights. That belief is understandable, but it's incomplete. Because at a 366.26 hearing, the judge is not deciding whether you are a good parent. The judge is deciding whether the law allows them to choose adoption over everything else. That distinction matters more than most attorneys ever explain. At this stage, the court's focus narrows dramatically. The judge is no longer weighing services, progress, or effort. The question becomes, is adoption the appropriate permanent plan under the statute, and do any legal exceptions apply? That's it. The first thing judges care about is statutory clarity. Judges at 36626 are bound by a very rigid legal framework. They are not free to make emotional decisions. They are not allowed to give one more chance unless the law permits it. So when parents come in arguing fairness, love, or regret, without tying those facts to a specific legal exception, the judge may listen politely, but it doesn't move the decision. What moves the decision is whether the record supports or defeats adoption under the law. The second thing judges care about is the strength of the child's adoptability evidence. Not whether adoption sounds good in theory, but whether the department has actually proven the child is adoptable. That means age, physical health, emotional stability, behavioral issues, and the availability of a willing adoptive placement. If the department's evidence is vague, conclusory, or copy and paste language, that matters. Judges notice when reports lack specificity, but they will not fix it for you. Someone has to point it out. The third thing judges care about is whether a legally recognized exception applies. Not every relationship qualifies. Not every bond qualifies. Judges are trained to look for very specific elements: frequency of contact, quality of interaction, parental role versus friendly role, and whether severing the relationship would cause substantial harm to the child. Saying, "My child loves me," is not enough. Saying, "We have a bond," is not enough. The judge is looking for evidence that termination would be detrimental, not just sad. The fourth thing judges care about is credibility of the record, not last-minute emotion. At 36626, the court relies heavily on what is already documented. That means visits, notes, reports, and testimony that occurred months earlier. Parents often believe this hearing is their moment to finally be heard, but judges are not evaluating you based on a speech. They are evaluating the consistency of the case history. That's why preparation for 366.26 must begin long before the hearing itself. The fifth thing judges care about is appellate defensibility. This is something most parents never hear. Judges know their decisions can be appealed. They want a record that shows they followed the statute, considered the required factors, and applied the correct legal standard. When an argument is framed clearly within the statute, when it gives the judge a lawful path to rule in your favor, that matters. Judges do not want reversals. They do not want remands. They want clean records. The final thing judges care about is whether delaying permanency would truly harm the child, not whether it's inconvenient, not whether it's emotionally difficult, but whether delaying adoption would undermine the child's need for stability. If the department cannot articulate that harm clearly, the court has discretion. But again, only if someone raises it properly. So here's the hard truth. 366.26 hearings are not about persuasion in the traditional sense. They are about precision. The parents who lose are often the parents who were never taught what the judge was actually deciding. The parents who still have options are the ones who understand that this hearing is a legal chess match, not a morality test. If you are approaching a 366.26 hearing, or if one has already been set, time matters, strategy matters, and silence can cost you everything. This is not the stage to hope the system sees your heart. This is the stage to make sure the law sees your case. I am taking a very limited number of emergency CPS cases for strategic intervention only. This closes soon.